Welcome, everybody. Welcome, everybody, to our Friday afternoon webinar series. I am, as always, Chris Irons, former Commissioner for Body Corporate and Community Management, Strata Advisor with Hines Legal. Today, also from Hines Legal, Frank Higginson, partner. Frank, welcome.
Welcome. Hello,
yes.
everyone.
Now, Frank is in a new locale for today's webinar, but he will be providing the same usual quality service nonetheless. Just a reminder, please, to like and share, get the message out there. The more the merrier for these sorts of things. Getting the message out, getting the content out is essential. We'll get better feedback that way. We can improve the webinars. We get topics, better discussion for everyone. You can also ask us questions. Just post a comment to Facebook. We'll get through as many of those as possible. But as per the title on the screen today, may the enforce be with you.
So you did that on your own.
Yeah.
That May the 4th stuff drives me nuts.
Yeah.
So I didn't know you were a Star Wars fan.
No, in fact, I loathe Star Wars, Frank. So that's just my concession to it. Enforcing bylaws. So we talk a lot about bylaws. Everyone talks a lot about bylaws. There seems to be, though, this, would you call it, Frank, a bit of a barrier or an obstacle towards how do we actually make them work? How do we enforce them?
And as I actually sit here and look at bylaws, that word on its own, and this is completely unscripted, ladies and gentlemen, because I didn't know Chris had called it that title until I logged in about 2 minutes to 2 with some technical difficulties. But the laws itself seems to sort of imply that it's fixed, it's structured, it's something you can actually do something with, that a lot of people don't actually understand that bylaws don't necessarily have that same ability.
That's right.
Particularly if they're not lawful in the first place.
That's right, Frank. And I actually would take it a step further. I think that if you're struggling with the concept of bylaws, what they are and how to enforce, how about thinking of it in a judicial way? Because with a bylaw, what you're in effect doing is you are alleging, or if you're saying someone's breached a bylaw, you're alleging they've done something wrong. You're alleging they've committed, and I'll call it an offence for want of a better expression, but you're alleging they've done that. So just as it would be the case in a court, a process has to kick in at this point. You can't just allege somebody has done something wrong and then that's it. They don't get any right of reply. So like any of those sort of processes, there's an allegation, there's evidence, there's a trial, if you want to call it that, and there's a verdict. It's a bit simplified, but I think it's actually useful to think of it that way. And when we talk enforcement, we are talking effectively about the trial phase, aren't we, Frank?
We are. We are. And I think probably the starting point for me with bylaws a lot of the times that just because it's registered doesn't make it lawful.
Yep.
So the whole bylaw registration process, I suppose if you go back over time, there's 10 or 11 standard bylaws at the back of the BCCM Act, which is the standard schedule that I suppose it recommends that bodies corporates have if bylaws haven't otherwise been registered. People can add to them with whatever they want over time. And the way a bylaw gets created is a motion goes to general meeting. That motion is approved normally by special resolution. So effectively 2/3 of those who voted in favour of it, not a 2/3 vote of the building as a whole. And then it goes into a CMS, which is the Community Management Statement in Schedule C, and that bylaw is then registered. But no one ever checks whether that bylaw itself is lawful or enforceable. So I can put up a bylaw that would say, for example, with respect to Chris, that all former commissioners shall not be allowed to live in this unit complex.
And rightly so, too. Yeah.
They're just annoying. So if that went up and that was approved, that goes into Schedule C, and if it's registered within 3 months of the passing of that resolution, because there must be some currency to these things, then that's it. It's in the bylaws, but it doesn't make it right. And it doesn't make it enforceable. And it doesn't make it lawful.
It's a really good point, Frank. Really good point. So that's one kind of aspect of it. And the second aspect of it is when we talk about enforcement is that enforcement is the job of the body corporate, and to be more specific, the committee. So again, I say this till I'm blue in the face, but I'll say it again. The committee is the executive decision-making arm of the body corporate responsible for day-to-day actions on behalf of the body corporate. They're the ones who enforce the bylaw, not the caretaker, not the body corporate manager, not the chairperson or the secretary acting by themselves. It's the committee taking a decision as a group to enforce, or indeed not to enforce. So with all of that, sorry.
But I might just chuck in a tiny little management rights piece there, because I suppose this could be a seminar on its own, webinar, whatever it is, in terms of bylaw enforcement itself, is that quite often management rights agreements, older style management rights agreements, are usually clause C. If you go to clause 4C of your agreement, it's an older one, this is where it will be. That will say something along the lines of the resident manager must police the observance of the bylaws, and the manager has the full authority or the equivalent authority of the body corporate to take enforcement action with respect to them. That clause is simply invalid.
Yep.
So a committee or a body corporate can't delegate its decision-making powers or its abilities in that context. The less onerous management rights clause is along the lines of the resident manager will monitor the observance of the bylaws and report serious or persistent breaches of them to the committee,
yep.
which is what should happen. So sometimes we have these issues where someone looks at a management rights agreement, the same as they might look at a bylaw, think, well, it says that must be right, and it's not the case. Because
That's right.
Committee is it.
Well said, Frank. Well said. When it comes to bylaw enforcement, there is an informal bit, and then there's a very, very formal bit. The informal bit is, unsurprisingly, a bit of communication. So, you know, if there's a bylaw you believe is being breached and you want to enforce, the very first step is to actually approach, have the discussion. So a good example, parking. So rather than go militant and call a tow truck within a nanosecond of spotting somebody apparently parked in the wrong place, have a discussion with them. Did you know you were parked in, assuming you know where they are, of course. But this is what I mean by the informal step. You don't just go straight to the trial phase, if we keep using that analogy. You try and seek some resolution at the start. You try and get something solved at the start. That's assuming that it's safe to do so, that it's reasonable to do so. There might be some instances where it is not. The reason why we suggest that is because that is a far quicker and far less stressful way of resolving the matter. Because if you go down the formal step, which we're about to talk about, you're up for a very long, very involved process, aren't you, Frank?
You are. You absolutely are. And I think the other starting point is a lot of people might not even know bylaws exist.
Yep.
That's what's a bylaw. You know, we still have people sometimes whinging about having to pay body corporate levies. I pay my rates. Why do I have to pay these body corporate levies as well? I've already done that. No, you haven't, mate. So
that's right.
There used to be on the front of, I suppose this was part of, you go back to, there we go, Campbell Newman's red tape reduction program. They reviewed at that stage the disclosure regime for people buying into community title schemes. There used to be a big warning statement on the front saying you should look at this, you should read bylaws, there are bylaws, and even actually back then, what used to have to go with the contract was a copy of the community management statement with the bylaws itself. So there was, in a sense, sort of some forcing it down people's throats in terms of here's what you are going to become subject to, and that all went away as part of that regime. So people buy these things, and dare I say it, you go to the cheapest chips conveyancing, you get your purchase done for $500. It includes the bare minimum conveyancing protocol standards, which are some searches, a 15-page warning letter at the start of it to tell you all the things that we're not going to tell you about for $500. Not that we do this, and people don't even know they've got them. So that bylaws exist, that there are rules, and that there are expectations of living in a community title scheme. And I think probably part of that communication piece is not when someone's parking in the visitor car park, they get the big A3 sticker on their window, or they get confronted by the resident manager or the chairperson blowing up about, you know, you can't park there, you're a, insert whatever expletive you want. Yep. That just descends downhill real quick.
It does indeed. It does indeed. So look, assuming that your informal approaches don't solve the issue, then it's up to the formal process. And that formal process, you would hope and expect, would be done by the body corporate, but there are options for an individual to do that in the event that the body corporate does not or refuses to do so. So look, the basic turn of events is that the body corporate identifies that somebody is breaching a bylaw, and this is the, I guess, the ideal utopian version of events. The body corporate identifies that someone is contravening, that's the technical term used, a bylaw, and gives them a notice about that. the terms used in the legislation are terms like the accused person, the complainant, and things like that, which again reinforces that idea that we're talking about an almost judicial process from go to woe. So the body corporate gives the notice to the person they believe is breaching, and that notice sets out all of the details. There are two types of forms for that, a Form 10 and a Form 11, both published by my former office. You don't have to use those forms, but why on earth you wouldn't use those forms is beyond me, because it contains all of the information. If you decide to do your own notice and you don't contain all of the necessary information, it's kaput. So that is a common way in which bylaws get unstuck really quickly. Yeah. So then we follow that down. We follow that process down. If the contravention is remedied at that point, happy days, hallelujah, and away we go. If the controversion, if that's a brand new word.
Friday afternoon, mate. It's almost alcohol time, not coffee time. Betwixt and between it.
You've got me all flustered now, Frank. If the contravention is not remedied by the accused person, then there are two options open to the body corporate. By far the most common one would be that the body corporate goes to my former office and lodges what's called a Form 22 application for conciliation. And that is the start of that very, very formal process. Bylaw disputes will always start with a conciliation in my former office unless there is some pretty dramatic reason for it not to. And there are not many of those situations because, Frank, conciliations lend themselves to solving bylaw disputes.
They do. It's actually people talking rather than throwing stones at each other via emails and all those sort of things, which is the more, I suppose, advanced conciliation is what Chris offers in terms of mediation services. So I think the whole that bylaw process, it's interesting. I think that the first thing too, and I suppose what we have is we've got a checklist for bodies corporates that to enforce bylaws. The very first thing on that checklist is that the bylaw itself is lawful. So we've done a few of these webinars now. We talk about Section 180 of the BCCM Act. If you're going to have a bylaw that comes unstuck, that's probably where it's going to come from. So, part of our job, if you can't figure it out, we're very happy to help. But if you want to email us at some stage at that info address asking for that checklist, we'll quite happily send it to you.
Absolutely.
But is it lawful? And then it sort of works its way through the various processes. And the other thing I think, mate, that's really important is there's no self-help remedy for bodies corporate. So the only way you can enforce a bylaw is via an order from the Commissioner's office. So if, for example, and mate, pets comes up all the time, if someone brought a pet into their property without approval, the bylaw they breached is actually not seeking consent. So what they need to do is make an application to the body corporate to get that consent or approval, and then the process follows through from there. What the body corporate can't do is have the chairperson go and get the master key, sneak into the room at the dead of night, grab the cat by the scruff of the neck, put it in a cat cage and take it to the RSPCA as a lost pet. Yeah. Cannot do that.
That's right.
And that's where we get to with towing of cars. And I just looked up and saw the comments there, is it okay to tow a car away? So that is bylaw enforcement that you can only do with an order from Chris's office.
That's right.
Former office.
Yep. Former office.
Michelle's office now. Sorry.
Yes, Michelle's office now. Quite right. However, there is a flip side of all of that. So this is where an individual gets the bylaws enforced. So the way that is done is the way it should be done, again, as an ideal, is that an owner or indeed an occupier, a tenant, if you like, issues what's called a Form 1 to the body corporate. And basically that Form 1 is putting the body corporate on notice that I, as an individual, expect them to enforce this bylaw, which I believe is being breached. So Julianne, as always, thanks for tuning in, has highlighted that Form 1 there. We'll get to the balance of your question in a second, Julianne. So at that point, the body corporate has a decision to make, or the committee has a decision to make. It's been presented with an allegation. I think this bit's really critical because I think this is where things go awry really quickly. Just because so let's just say, Frank, you're the committee and I am an owner. So I have decided that Ethel down in Unit 1 is breaching the noise and nuisance bylaw. And I put a Form 1 to you as the committee to enforce that. You receive that, but Frank, your first reaction doesn't and shouldn't be to say, okay, let's just enforce it right now because there's a breach. You actually need to be
get it and string her up from it.
Yeah, you need to be satisfied that it actually is evidence, don't you?
Absolutely. So your complaint about her noise is going to be, mate, the same thing we talk about every week. When did it happen? How often does it happen? Where's the recordings of it? Can we please have some evidence? So you're saying, so I suppose this in effect is putting the committee, you want another parallel, almost acting as an adjudicator in the sense of, we've got a complaint about a certain pattern of conduct. Where's the evidence of that conduct? A general whinge about noise is not that. And
That's
then
right.
I suppose, and then it's up to the committee to make a decision about, well, what are we going to do about it?
And this is where it is essential that you, as challenging as it sounds, you've got to put emotions out of bylaw enforcement because it becomes incredibly clinical at this point. And it needs to be clinical because otherwise it will fall down and you will go right back to the start and the situation will still not be resolved. So goes to the body corporate. Again, we use this analogy where Frank is the body corporate. You've got 14 days as the committee to decide or to advise me about what I'm going to do about it. And the obvious decisions that you make are enforce, not enforce. The one decision that they really should not be making is do nothing. Or the other option is to ask for a bit more information, which is quite reasonable under the circumstances. So you might have, Frank, as the committee, might have a bit of information there, and it's like, yeah, there's probably a problem there, but I just need to know a bit more about what happened on the night of the 22nd of May. It's quite reasonable to go back and ask me for that information if I have it. And if I do, great. If I don't, the committee still needs to decide at that point. At that point, the decision's made, and if the decision is enforced, we go back to the process I just spoke about earlier. But if the committee declines or says, you know what, we don't actually accept that the bylaw is being breached, there is then the opportunity for the individual to pursue that matter themselves. And there are two ways that gets done. Either, and Julianne, this goes to your question, either there's an application lodged in my former office to have the body corporate issue the Form 1, or you can pursue the complaint directly against the offending party. But to do that, you must attempt some self-resolution. You must actually attempt to resolve the matter yourself with that individual. That can be very tricky in a bylaw situation, can't it, Frank?
It can, and it's just this personal conflict that comes up all the time in bodies corporates that usually, and mate, as we see with the mediations and the rest of it, the thing where people are fighting about is not necessarily what the cause of their dispute is. So your complaint to me about Ethel and her noise probably relates to some blue that you had with her 6 months previously over something else, and this is now your attempt to square up with her via the committee.
Yep.
If I was going to cast nasturtiums, that's just the way it is. So here we are. This is what we're trying to get people educated around in terms of helping to avoid the need to go through this process. As much as we're talking about it, but it's that communication piece again and again and again that prevents a lot of the need for this.
Absolutely. A few things to be aware of about the enforcement process. A few things to ask yourself if you think you're in this situation, be it committee or the individual. Frank said at the start, do you actually have the right bylaw? I have seen plenty of cases go to my former office, get all the way to an adjudicator, who then does a couple of searches with titles and finds out that the bylaw that the committee has been enforcing all this time doesn't actually exist.
And mate, the trick for that, that's a really interesting one, because the way, interestingly enough, every body corporate has a title deed in effect in the titles office. So, and that is lot 0 on the survey plan. So if you're lot 1 on BUP 5462, lot 0 on BUP 5462 is the common property title. And against that is going to be registered all of the dealings with respect to the common property for the entire history of that scheme if you do an historical title search. So that will show the day it was registered. It'll show all the bylaw changes over the years. We'll show any easements. It'll show whatever else it might that's registered, encumbrances, BMSs and the rest of it. And the very last document, or the very last CMS, is the document that is the current set of bylaws. So the way it works now, if you've got an older scheme, is that, particularly, I suppose, mate, pre-1997, if you go back to the 80s somewhere, the way bylaw changes used to work is there was an original set registered, then you would delete bylaw 12 and add bylaw 13, and then amend bylaw 22A by insertion of these words. And all of those were separate registered dealings. So to get a consolidated history of the bylaws, you have to search all of those. CMSs did away with that. So the current bylaws are the very last version of the CMS registered, and most competent body corporate managers will have a copy of that handy, but it's worth just checking sometimes, because I have seen that, Chris.
Oh, absolutely. And it's a terrible outcome for everyone.
Yes.
You've wasted so much time, money and effort on that. I appreciate that the bylaw enforcement process that Frank and I are talking about is a bit complicated, a bit convoluted. And I hear everybody cry, oh, if only there was some sort of diagram to assist. Well, there is, in fact, a diagram to assist. So I'm just posting it now in the comments. Hopefully it would help if I press send, wouldn't it?
Now, where did this diagram come from, Chris?
Where did this diagram come from, Chris? It comes from my former office, and in fact, my name is still on this one. So this is what's called a practice direction. It's the practice direction 7 about bylaw enforcement. So practice directions are the guidance issued by my former office, which tells you how a dispute is going to be handled or likely to be handled in the office. Because we were having so many instances of people not understanding the bylaw enforcement process, and it's not just us making up the rules, I've got to stress, it's very, very, very detailed in legislation. We came up with this practice direction and a flow chart. So there's a couple of pages, and then the very last page is a landscape flow chart, which sets it out, I think, in brilliant terms. Please have a look at that via the link. We were going to show it to you on the screen today, but for some reason, attempting to do so, it kicked Frank off the telecast, and we didn't want that. But that is the absolute #1 best way, if you are confused, to understand how bylaws get enforced. It is there's still a lot of content to absorb there, don't get me wrong, but it is a much clearer way, and you see the map and you see the path. You see the outcome, which is really important. While you're having a look at that, I'll go through a few other things that you need to talk about. The evidence thing, Frank and I touched upon that before. There's no point pursuing a bylaw breach if you can't evidence what it is that you're talking about. So it's all well and good to say, that dog is barking, I want the bylaw about noise and nuisance to be enforced. How do you know it's that dog? Can you show? Can you prove? I've seen matters get to an adjudicator about a barking dog, and it's got audio recordings and a log, and the adjudicator has looked at it and gone, well, I don't know which dog that is. I can hear a dog on the tape, but I don't know if that's the dog next door. I don't know if that's the dog in the building next door. So it's pointless pursuing these matters unless you can absolutely show. Another key point about bylaw enforcement, bylaws are enforced against an individual. You actually have to name someone, an entity. So this is where it gets problematic. If you don't know, if your next door neighbour is breaching, but you don't know who they are, you're going to have to make some efforts to find that out. And that's pretty tricky, isn't it, Frank?
It is. And it's actually, it's not suing someone in, I suppose, the true sense of the word from a piece of litigation, but still is a bylaw enforcement process is still having a crack at someone. That's the reality of it. So if you can avoid that, that's great. But if you don't have a choice, then you've got to do what you got to do. And mate, one of the other things I think that everyone complains about, and I know when we're doing seminars together before you joined us and the rest of it, it's the time. These things take time to work through the Commissioner's office. So if your complaint is that barking dog today, it's going to be 4 months before you've got an outcome, but that's just the way the system works. Right, wrong or indifferent, that's the way the system works. So the proposal for some legislative reform around bylaw enforcement that I suppose was a couple of years ago now, we haven't seen any legislation on that. We're talking about legislation on the modules at the moment. They were talking about sort of creating some mechanisms, particularly around towing cars, that might allow for some more immediate style activity as opposed to having to go through the Commission's office. But at the moment, that's not there. So this is just the reality. So, and the place to direct that question is to a local member of parliament if you feel strongly enough about it, because there's nothing Chris or I can do about it on this side of the fence with the legislation being what it is.
Or your prospective member of parliament, for that matter.
Yes.
Just back to naming the person, I do know of one instance where an adjudicator has made an order without the name of the person. They have actually referred to them, I think, as the occupier, or indeed I think they identified them by the rego plate on their car. But that's a pretty rare circumstance, and I think in that case, if memory serves me, the applicant was able to demonstrate all of the steps they'd tried to take to identify the person.
So it's not, I just don't want to bother going to knock at their door. I've had a red hot go trying to figure out who they are and I couldn't find it.
That's right. So that's the exception, though, that proves the rule. Couple of other things. Frank has said it's a long process, but the important thing is, if you do enforce and you go to my former office, it's going to start at conciliation, which means you might as well try talking at the start, because that's where it's going to go anyway. You can't just rock up to the Commissioner's office and say, I don't want to conciliate, I want an adjudicator's order right away. No, it will actually go there. So if you're going to be forced to talk about it anyway, why not actually try that right at the start? And probably the final point, everything that Frank and I have spoken about today, I expect there's a few people sitting back watching this who are going, oh, bloody hell, that is a real rigmarole, that process. Well, yeah, it is, but if you don't follow it, I can guarantee you will be rejected and you will go back to go. Or you will not pass go and you will not get $200. You will start all over again. So all of the work you've put into that, if you haven't followed all of the steps, if you haven't crossed the T's and dotted the I's, you'll go right back to the start and the situation is made worse. We might try a couple of these questions, Frank. Julianne, we've got yours already. Rian, is it okay for the body corporate paid security guards to raise owner residents flouting the bylaws? So I think if I understand that correctly, what you mean is there's security guard on site, should they be raising potential bylaw breaches? I don't see why not. Just to say it's not their job to do anything about it necessarily. So
mate, I'm not sure we've got Julianne's question there too. If a committee member calls ordinary members' names in front of contractors and it's breach of bylaw, I suppose, is there a bylaw saying that you can't call people names?
Sorry, I assumed, I answered that on the assumption there was, but Julianne, it's really important to check that there is, I think. Yeah.
Not that I think that's necessarily lawful either. There you go.
Rian again, is it okay to tow a car away? No.
With an order from the Commissioner's office, yes.
Yeah, with an order of the Commissioner's office, yes.
And I think stickers are the same thing. That's bylaw enforcement by another name, and same as wheel clamping is.
Rian again, thanks Rian for continuing to tune in. If bylaws have been registered without going to a general meeting, are they valid? No. In a word, they're not. No.
Like giving black and white answers. That's excellent.
Yeah. If the alleged offender is a renter, what chance of naming them? That's actually not a bad point, Wendy, because the only way that, well, not the only way, but the most obvious way of finding out who a renter is by asking them, and they might not tell you. The next most obvious way is to actually contact the real estate agent, who is their landlord, effectively. But you can almost be guaranteed that they will say the same thing. I'm not telling you anything about them. So then your next step, let's see what you think here, Frank. You'd have a look at the roll to see if their details were registered on the roll. That's the body corporate roll. So if they've got a lease of more than 6 months, they should be registered on the roll. So that is probably your best bet, Wendy, as to how you find out. There are other options to do that.
Still their mail.
Yep, still there.
I'm joking.
Do you know, Frank, I was just about to say that actually, but yeah. So, no. Yeah. They would be the most obvious ways of finding
and
out.
I suppose, and then you're back to where you were before in terms of we've knocked on their door, they've told me to go jump. I've tried all these ways to try to find out who they are, and I can't. So they are the occupier of Unit 37, and these are the things they're doing.
And you would include the steps you took. So if you emailed the real estate agent and said, I've got this serious problem going on and I need to have this issue resolved with one of your tenants, and the email and the real estate agent replied and said, I refuse to tell you that on the grounds of privacy or whatever. That's part of your grounds for an application. I tried. Here are the steps I have tried. You go and have a look at the role, and for whatever reason, their details aren't on the role. You've done the search, and the answer is nil. That's another piece of evidence that you supply. Yep.
I see Julianne does have a bylaw there about speaking in derogatory manner. So I suppose that might be our typical sort of nuisance bylaw. So in that sense, then potentially it is a breach of bylaws.
Absolutely. One last question. Good one, George. If a committee knows a bylaw is invalid and unenforceable, is the committee obliged to enforce it? Technically, yes, they are. Technically.
Yes. And mate, I'll turn this into a blatant pitch for the legal services we offer. One of the things we do for Bodies Corporate, obviously, is review bylaws. Our standard proposal will set out for Bodies Corporate the bylaws they've got, by and large, examples of them, they're unlawful, and include some of the bylaws that a body corporate hasn't got that they should have, because things change over time. And I'm yet to send one of those that doesn't have at least 4 or 5 invalid bylaws in it. So from my perspective, back to what a committee acting reasonably is, if a committee knows the bylaws aren't right, on what possible basis are they leaving them in there? Because, and sorry, Chris, I'll just keep going on this for 1 second more. One of the things we have with committees all the time is, well, Frank, can you put this bylaw in? Because even though it's unlawful and unenforceable, we're not going to, we'll just leave it in there. We'll use that as a bit of a disincentive, and we won't enforce it if someone pushes back on us. Because, and my immediate response to that is, don't do it don't do it, but Google is there. If you go and Google a whole bunch of stuff about bylaws, you're going to find webinars like this. You're going to find our content. You're going to find whatever it is. So it's almost impossible to stand over people with invalid bylaws now. And the other thing is that today we're having this conversation. It's unlawful. I know it's unlawful. The body corporate manager, who's a party to this, knows it's unlawful. But in 3 years' time, none of us are going to be there. And then we're back to where we started today with, it's in the bylaws, therefore I should be able to go and do something about it.
Absolutely, Frank. Well said. I think that's a really great point on which to finish. We have come to the end today.
Yet again.
Thanks, everyone. Some good comments and good questions there. Bylaws are tricky. Very, very tricky thing. But you can get a result. You just have to be methodical about it. Again, don't forget to like and share. Join us again next Friday at 2 p.m. for another exciting instalment of our webinar series. We may have some interesting topics. Well, we always have interesting topics, but we may have some particularly interesting topics coming up.
And dare I say it, this one got to the top of the list because it was viewer initiated. One of our frequent viewers said, why don't you guys do this? And we did. So if you've got something specific you want us to cover, feel free.
Absolutely. And we will do our level best on it. Don't forget to like and share. Follow us on Facebook. You'll find out about these sorts of events. But for now, Frank, as always, thank you.
Done. See you,
everybody. Thanks very much. See you later. Bye.
Bye.